Hey, good afternoon, everyone. Thank you for staying with us on a CPDP Friday afternoon to talk about data subject access rights and about Digital Omnibus. As most of you, of course, know, when people, generally speaking, talk about data protection, they focus a lot about consent. But even where consent is indeed a solid legal basis and is expressed in a valid way, even according to the high threshold of the GDPR, it is not the end of the story. Even once one consents to the processing of one's personal data, they still keep rights. And one of the cornerstones of data protection law has been for decades the right of access to personal data. At the same time, and the previous panel in this room talked about it as well, there has been a lot of discussion about the potential abuse of the right of access to personal data. And this has led the European Commission to make proposals to amend the GDPR with the aim of both, at least the stated aim of both simplifying law with regards to data protection and the right of access, while keeping the same level of protection for fundamental rights. So in this panel, which is brought to you by the ANR Data Rights Project from the University of Paris 8, we are going to talk about what the value of the right of access is, both on an individual and a collective level. What is it used for? Why is it there in the first place? How and why are we talking about the risks of abuse, and then we will move on to whether or not the panelists who are here today with me think that the proposals made by the Commission are the right ones to tackle the issue. So today with me I have the pleasure of introducing first of all René Mailleux, who is Assistant Professor of Data Protection and Privacy Law at the Open Universiteit in the Netherlands, and he wrote a lot of papers and many other publications on the right of access. So if you want to learn more about the right of access, I warmly recommend that you read his excellent work. Then we also have the pleasure of having Jacob Gursky with us on the panel. Jacob is technical advisor with a background in privacy engineering at a company called the Privacy Company in the Netherlands, and they work on large-scale data protection impact assessment that incorporate data subject access rights as part of the process. Then we have Florence Gaulier, who is partner at Vercaen et Gaulier. She's been an IT lawyer for more than 22 years. She's a member of IFCDP, the French DPO Association, and she's also a member of CEDPO, the European umbrella organization of DPOs. And last but not least, we are also welcoming Jessica Pidou from Personal Data IO, which is a leading NGO in Switzerland dealing with data protection and data protection in general, but a lot of their work focuses on data subject access rights, so her feedback from the field is very appreciated. Thank you all for joining us. Without any further ado, I will ask a first round of questions to each of our panelists, starting with René. René, can you please tell us a bit more about what the right of access is in the first place? There has been a lot of discussion on what is the purpose of the right of access, and you have studied it extensively, so yeah, why is it there in the first place?
Yes, thank you for the introduction. So I think, as most of you will know, the right of access to personal data is in Article 15 of the GDPR, and it's in the Charter. And in essence, it gives people the right to ask whether a controller uses or processes their personal data, and if so, then to provide access to that personal data, and importantly, to give lots of different information about how that data is being used. What is important, I think, about the why and the history is that indeed, as has already been said, the right of access to personal data has been basically part of the thinking about data protection since the very early days. And the early days are basically the moment in the end of the 60s, beginning of the 70s, when computers or databases are starting to get first into the public services and larger companies, and then spread, like technology changes, of course, but in the beginning it was still pretty centralized. And the question was, how do we need to change our laws with these, when these computers are going to change everything that we do? And data protection law is the response to that question. And it was pretty clear from the beginning that almost everyone agreed that the right of access to personal data should be part of that response. And I think you can say that it has two main aims. One is the most known currently, which is it allows people to verify the lawfulness of the personal data processing, so to know what's going on with your data and to know whether that's lawful, and to do other data protection requests. So maybe if the data is inaccurate, to change it to the correct, to make it accurate. But another thing is that it has a much broader emancipatory aim. The idea that when your data is used, it's your data. And when you have the right access, it changes the informational power asymmetry. And I think from the beginning, there were voices that said, actually, to have that in a society, computer or no computer, is actually a very good thing. This idea that when another entity has your data, you have it, that creates a more power balance, and you can then use it for any aim, any legitimate aim. So this whole discussion that we now have about abuse is often about that question again. Is it only for verifying lawfulness? Is it more? And I think the history pretty clearly shows that that debate was, by most thinkers and policymakers at that time, said like, no, it is for a broader purpose.
Thank you for this reminder of the history of this right, which indeed has been around for a long time, at least in the countries that were early adopters of data protection law. Now, Jessica, as the director of this leading data protection NGO in Switzerland, personaldata.io, you have worked with a lot of data subjects, helping them also access their data. Can you tell us a bit more on why this right is so important to your NGO? Because you have made it a cornerstone of your work. So why is it so important? What is the value of this right on the ground? We have heard a bit about the theory, the emancipatory aims. Do you see that as well on the ground when you work with the people that you're helping?
Yeah, thank you. So for us, actually, what we see is it's a means to understand what's happening in today's digitalized society. And I'm also a sociologist, by the way, at the University of Neuchâtel, so I'm also interested on the social impact of our datification that is going on today. And our physical lives and digital lives are connected, are intertwined. So when our activities are increasingly digitized and there is data collected about us, this right of access actually is a means, and a very important one, to try to understand. Is a first entry point to know what's happening in this digitalized society and how we perceive, accounted, measured by companies. It is also for us a leverage to start contesting the relationships of asymmetry that we are seeing, and relationships of powers that are between platforms, companies, and the users, the data subjects at the end. Is again a new entry point, and maybe the main one to say, I am gaining insights also about the company and what's happening within this company. And also it is a means to understand the consequences of such data collection processes. It's for us actually, what we do is we help data subjects exercise their data rights. From the very basic point of who is the data protection officer that we have to contact, and then we develop tools and methods to analyze the data that is recovered. And And it is actually through the rights of access that we get the first materialization and visualization of the data that is collected about us. And these are facts for data subjects, for all of us in society, to say something about these companies and the data collection and the purposes behind. So we can actually, through facts now, with the right of access, start to forget these phrases that we hear usually, not, I have nothing to hide anyway, it's okay if I get a free service. When people start to see and realize that there are tons of files and data points about yourself, then you start to question really this relationship, you start to have facts to contest what is said about you and so on. So this is why it's important in our experience.
So we've heard about the history of this right. We've heard about why it matters so much, to the point that it is one of the pillars of the activities of some NGOs. But we haven't heard yet from the data controllers. So I'm now turning to Florence. Does the right of access also play an important role in the lives of data protection professionals and in the lives of data controllers?
Yes, of course. It depends on the sector of activity, of course, and also on the size of organizations. But on average, it's clearly a right that is very important in the daily life of DPOs. When we look at the figures, it's not so... it can be surprising, because when we looked at the EDPB coordinated enforcement action in 24, there were not so many high figures regarding the number of requests. We can see that only 9% of the respondents received more than 100 requests a year, which is not so many, and half of the respondents received less than 10 requests. So when we look at the figures, it could be seen as not so important. But in the daily work, even if you receive only 10 requests, it can be a lot of work. So it's not a question of number of requests, it's really the quality of the request. And for me, there are also two ways where the access right is really important in the life of a DPO. The first way is a preventive action, because when you are DPO, you can use the access right as an argument to implement the other fundamental rights which are provided in GDPR. Because when you explain, for example, to your internal teams that a data subject will have access to all data that you have, it can help to educate your team so that they do not collect information that are not useful, or write information in a form which are not useful, because if you know that it will be accessible to data subject, you will not do the same. So for this minimization principle, it's important to use the access right for DPOs. It's the same for the data retention period, because if you have to give the information that are obsolete, you will show that you have kept too long data. It's also the same for the transparency principle. If you have to show when you give your data or the information on the processing that you have made processing that you had not informed before. Every principles are linked to the access right, and I think for DPOs it's really useful. But there is also another part of the access right which is important in the daily work of DPOs, which is not so good for them. In some cases, it's really a nightmare to deal with it, because there are some cases of, I will not say abuse, but misuse. This part must be really also seen, because that is why the European Commission wanted to change the GDPR. So we cannot avoid to talk about these cases. I don't know if I have time. Yeah, there are two cases that are really complicated for DPOs and that are more and more frequent. The request from former employees who are asking for all their emails, all their messages, even if we know that they don't really want to have them. In reality, it's more to harm the former employer. And the other cases we had in France 2 years ago, we had a consumer association who built a tool to facilitate data access right requests, but without explaining really how it works and why it is useful. And some DPOs received more than 20,000 requests in the same week, even from data subjects that were not in the processing, because people just used the tool asking to every organization, even if these people were not living in the town or something like that. So in some cases, it's really difficult.
Can I add something on? Very short. So I'm on the side of the data subjects perspective, and when you said this example of the former employees, right? It's one of our typical cases. We help at the association. We help content moderators in Africa, Uber drivers, delivery workers, cleaner, to ask a copy of their data, because actually what we see also at the association is that this right of access can leverage other rights. And now with the workplace being more and more digitalized, what we see is that right of access can also serve labor rights. So in our case, it's very important, this right of access, because we can get data that with the basic law of labor, actually, they don't get it. They could, but they don't get it, and then they come to us, and what happens after is that not only one worker asks it, but 5, 10, and then we start to have a collective power through this individual access, right?
Indeed, and thank you for giving some real-life examples, both of you, from what DPOs sometimes go through when they receive 20,000 requests in a week. And when we prepared the discussion for this panel, also with other members of FCDP and CETPO, they mentioned the fact that sometimes when they exchange emails with some of the data subjects could become abusive in their language, and so that had also a psychological toll on data protection professionals. But at the same time, and once again, data protection is about protecting humans, not data, and so Jessica rightly, I think, mentioned also the value both for individuals and for collectives. I'm now turning to Jacob, because maybe if you want, you can say a word about what kind of work your company does, to give some context on your intervention, because through this work you have also a lot of hands-on experience with these kind of things, and I was wondering whether on the ground you were seeing a lot of these abusive or vexatious or excessive requests, which has manifestly inspired part of the debate that we are having. So what do you see on the ground in the kind of work that you do at the privacy company?
Yeah, I need to contextualize two separate ways that our work involves data subject access requests. One way is filing them as a part of data protection impact assessments to get a better idea of what is happening, and that informs both the understanding of the technical processing factually and the legal analysis to basically audit if the controller processor agreements reflect in practice what is said in the policies, et cetera. And then the other version is more of what you were speaking to, of helping our clients respond to data subject access requests. And I have a little asterisk here in my hand, and I'm going to answer your question. Yes, we see vexatious requests, asterisk, asterisk, a whole bunch of asterisks, because we don't, I would say that for context, the data protection impact assessments I work on are typically very large companies. So it might be a bit different for smaller organizations. But we do see them, but we don't see them in a great number. I would describe it as something that we need to prepare our clients for, but not something that would require a grand reconfiguration. And the phrase that comes to my mind is throwing the baby out with the bathwater, which is like, I think it's important that efforts to curb abuse don't lump other forms of collective action into these vexatious requests, which I think I conceptualize them as very similar to a DDoS attack or something where you make lots of requests at once just to be vexatious. And the rule over the exception is that we receive, for the other part of the work where we file the requests, is that we receive incomplete responses. So is there such thing as a vexatious response? Because I think discussions of these mitigations against vexatious requests tacitly imply that the controller is offering a complete response when that is very atypical. So it's possible for, in some scenarios, for both parties to be doing something wrong. Good, okay. So, and I also, these DDoS style things are only one form of what could be considered vexatious if you have a broad definition of it. So, for example, we often receive pushback from companies that, hey, a typical data subject wouldn't be asking for everything that you know we're processing because of our technical tests. And our response is, well, you're still processing this, and it's about letting data subjects know what they could ask for in the future. So in theory, you don't need a whole bunch of people to be vexatious. You don't need to be a former employee. You could just have a very large but still valid request. So I think it's important to take a broad view of what could eventually fall into that bucket of vexatious asterisk, asterisk, asterisk.
Thank you. Thank you very much indeed. And maybe talking about some of the recent trends that we have seen both in the policy debate, in the practice on the ground, and also in case law. I would like to ask Jessica, how would you judge the current state of implementation of this right? Jacob mentioned that we shouldn't necessarily assume that it is always easy to get a full answer from controllers. Is that also something that you see on the ground? And maybe to phrase it in maybe a provocative way, are you still able to find cases where the answers are still useful? Do you have some success stories still? And generally speaking, is it satisfactory, the current state of play from the point of view of data subjects?
Well, the short answer is overall it's very poor. What we see as responses from companies, and I think we have tried a lot of companies already, different sizes. There is definitely a difference with large corporations that you can see that they are putting more resources on preparing their answers, and well, we are well known for our work on Uber requests, and Uber drivers get a lot of data, but this has changed over time. Sometimes we see less data, and well, this is one of the first problems. Like, we have incomplete data and inconsistent data across Uber drivers or data subjects of the same company. But then again, this is where we come to the collective value of the right of access, that when we help different data subjects in the same company to request their data, we start to observe better what is the functioning of the company and why some are receiving less or more, and then we can contest also that. So we get out from a fragmented view of a data subject to a more collective views and more complete landscape of data collection processes. We have a lot of problems that I can name. Just sometimes identifying the data protection officer or the right entity to whom we have to ask the request. Sometimes you don't find it. We have online forms that are by default, and there's no other way to contact the entity, and these online forms also limit you on the right that you can request. So sometimes we have to do 2, 3 right of access, but actually we also want the data portability, right? We also want the Article 22 about automatic decisions. And then we receive an answer with a no reply email. So you have to go again through the form if you're not satisfied with the answer. And then also, we have to create legal answers to these companies. It's not a straight one request process. We have to go back and forth with the data subject to contest what the company is saying. Sometimes answers like, you have 7 days to verify your identity, otherwise we canceled your request. Or, no, this is all the data we have about you. By the way, do you want to delete your account? Or answers like, everything is a privacy policy. Okay, this is not my request, right? And so many others I can say. What we see also is that there are format problems. Sometimes we receive data, even from this big company like Uber, the data didn't have unit labels, and we have to figure out that it was on miles and not in kilometers. And we asked the data for a Geneva Uber driver who speaks French, and we got all the data explanations in English, and the data, the variables are in English. So we also have this step of difficulty that we need legal expertise to contest the companies, so the company knows that we are equipped and that we are asking for this data, and then technical expertise, and this is only if we make a collective use of this, right, with associations, unions, researchers, that we really get the best out of it.
Thank you for this additional feedback from the ground, and also related to one of the things you said when you were asked, by the way, do you want to delete your account? In some of the studies that we conduct in the research project, we have seen 2 cases where the person doing an access request got the answer that their account had been deleted, which is sometimes absolutely not what you might want. So that can be an interesting one. Turning back to Florence, you did mention that sometimes quantitatively DPOs don't, or organizations don't necessarily receive a lot of data subject access requests, but still sometimes even just 10 a year can be a lot of work. So we understand that there can be also obstacles to the right implementation of this right. The CPDP, which is the French chapter of CEDPO, publishes a yearly index that shows that compliance with this right of access appears to be on the rise. So that is maybe good news coming from CPDP. But still, it also shows at the same time that a lot of work still needs to be done. So what can you tell us about this, and what are the kind of obstacles that we have to keep in mind when we have this discussion all together?
AFCDP, so the French Association of DPO, has been publishing an index on data access rights for 15 years now. So we have really good data. It is made by participants of the ISEP Master's Degree in Data Protection Management, which is a school in France. And the participant to this master sent dozens or even hundreds of data requests every year. So, and then they analyze the time to respond, the quality of the response, etc. And in 2026, the figures are quite good because 76% of the organizations responded on time to the requests, and in 22 it was 46. So we can see that there is really an improvement in France. It was not only French companies in the requested. The quality of the response also is better because half of the respondents had excellent or satisfactory response. So it's really better than before. But there are also some answers that are not so good because they are insufficient verification of the applicant's identity, unsecured tools to send the data, or missing data also. From the point of view of the DPOs, I would say that the source of complexity are quite always the same. Generally, the data are scattered in several more or less recent information systems, more or less designed to retrieve data. Today, it's really the case, even with AI. It's also not so easy to sort through data, the data involving third-party rights. It's really a work to do which is not so easy, even with the help of AI. One other problem is to have teams to find time to deal with these requests. It's not completely automatized. There is also still problems to recognize a request as a data access request. And also lack of documented internal procedures to do it. Even today, it's not always the case, especially in SMEs.
Thank you. It's still, I think, good to hear that this compliance is on the rise, and I think that the index that you're producing is also very important for us because it's really been a long-running one. So, yeah, so these efforts are starting to bear at least some fruit. I'm turning now to Jacob again. You talked in the first round of question about the data protection impact assessments that you produce. Do you see them as a way that can help address some of the obstacles that Florence mentioned, or are they just an added layer of bureaucracy? How can you address some of these issues in DPIAs? I'm also thinking about, for example, sometimes the security risks, which are also often mentioned in the discussions. There is always a risk that someone is impersonating one of your data subjects, and that it can create also a security risk. So, how do you deal with that in your experience?
Yes. Perhaps I am biased, but I see these data protection impact assessments as helping what you're describing, because essentially what we establish is a baseline for the processing. And one thing that comes up a lot that we've sort of made gestures towards in this conversation but haven't mentioned explicitly is the role of download your information tools in all of this. And often that in a DIY tool can itself be a form of deceptive design pattern, because the data you get from that is not everything you can get. But for most data subjects, it is sufficient. So something like a DIY tool could maybe allay some of those things for the bulk of data subjects. So instead of making it more difficult to make a DSAR because you have to include specific legal text to navigate the changes to the GDPR, if DIY tools were more standardized, instead of filtering people out from sending requests, you could send more people happy with their requests that they want. So the way I see our DPIAs is that we establish the baseline of what is possible to receive, and ultimately that's better for the controllers because the data subject can send a more precise request. For example, we are very meticulous about looking for telemetry and cookies and advertising data that's typically not a part of a DSAR. And rightfully so, a controller would say, we can't give you 80 billion terabytes of logs, but that usually means they don't return anything. If you read our DPIAs, which you should over at the surf table, you will see as a data subject things you can ask for, and then you can be specific. You could say, I want my logs, but only for this set of days. Yeah, and so, and one other thing that I think is core to this is that DSARs are a process. It's not something, it's not just a button that you press. And part of what we look at is that process. One of my favorite anecdotes of this, going back to what you were saying about accidentally having your data deleted, was we sent a DSAR and the company responded saying, we're giving you your data and we're super compliant because actually your account has already been blocked. And I was like, you never told me I was blocked. So the DSAR itself basically had no data, but because we were able to find a GDPR violation in the form of shadow banning that had nothing to do with the data itself.
Thank you. And indeed, I think you're also touching upon a very important point, I think, in this discussion that I would like to underline, which is that very often these download your data tools are not necessarily data access request tools, in the sense that they might not give you everything, but and so in some ways it can be a deceptive design. But at the same time, just because they don't give everything and might not cover every single situation where a person might have a need to have access to their data, it doesn't mean that it cannot help in many situations. And I think both elements are important, reminding us that it is not exactly the same thing and that there needs to be clarity on this, but at the same time, it is, I think, interesting feedback that these things could be helpful in many situations. I would now like to ask René about the current trends in European case law. There have been more and more decisions by the European Union's Court of Justice regarding the right of access. But we're also seeing more and more decisions in national courts. Would you say that the current trends are supportive of the aims pursued by the right of access? And do these recent decisions address the concerns raised by some of the participants, both from the data subject perspective and from the data controller's perspective? Of course, I'm thinking about, among others, about the problems raised by abusive requests, and we had the Brillenhortler case recently. But yeah, more broadly speaking, what are the big trends you are seeing in the case law?
Yes, thanks. I think a lot was raised by on this panel, and indeed is going on in the case law. And I think there's two major trends. One is that I think, especially the Court of Justice of the European Union, but then also national courts, are taking a pretty expansive view of what you have to provide, what a controller has to provide when they respond to an access request. But I want to be clear that when I say expansive view, I think they actually are saying exactly what the law is saying. Like, the law has an expansive view, and how I see almost all cases, yeah, no, indeed. Actually, you're wondering why this, you have to also provide this and that, and then the court just continues saying, yes, indeed, also this, yes, it's quite a lot, but also that, oh, we know it's a lot, but still, yes, also that. And I think that is good. A very welcome development, also because they're not just, they're saying it much better than I just did, because they all the time come back to, what's the point here? You have to be able to verify the lawfulness, to have full transparency over how data is being processed. And so that means when the processing is expensive, the right of access also becomes a very expensive right by nature. So that's one element, I think, that you can really see, especially in the last few years in the court's decisions. And then on the other hand, also regarding the purpose, I think already from early case law, like in Novak at the EU level, in the Netherlands, there was case law already also much before making it clear that you can also use the right of access for other purposes than just verifying the lawfulness of the personal data. So at least I know I started working on this right much before, and I was always saying, no, it's clear that the right can be used for more than just that. But now with Copie du dossier médical in 23, the court has unambiguously stated you can also use the right of access to personal data for other purposes. So yeah, these are the main lines. I think if there's one question that might be to some extent open, or that I think we ought to have a debate about, is not so much, for example, when you talk about these ex-employees, are they allowed to use their right of access? And I'm like, yes, obviously, in a way they are. And also here you can even go back to the discussions when the right of access got, for example, into the Dutch constitution, where in the constitutional debate, this was actually debated. Yes, potentially workers could use other rights to get access, I don't know, to their employee file or to certain personal data. But these other routes are often very complicated. They have their own complications. And at least in the Dutch debate, the voices that won out were like, and therefore actually it's good to have this very wide-ranging right of access that kind of supersede other existing access regimes. Nonetheless, I feel there is one question about proportional effort or disproportional effort. I think that's an open question in the law. Already in the first ever case on the right of access, now decades ago, the court did say something about proportionality of the efforts that a controller has to provide to give complete access. That was based on some very complicated reading of the then Data Protection Directive. And you see now a debate both in the legal literature and in courts that some people are saying, no, you have always the right on full access to everything that is personal data, no matter the efforts that a controller would have to put. And there are other voices that saying, no, there can be a limit to the amount of effort. And also in the courts, at least, for example, in the Dutch courts, you sometimes see judges bringing this argument explicitly. And I think that is, in some sense, might be a more fruitful debate to have than discussing about like vexatious or, oh, it's not requested for the right purpose. Not to say that I know where the answer to that question then needs to be, but I think there is an interesting open question.
Thank you. So indeed, generally speaking, case law that brings confirmation that we need to, at least based on the law that we have right now, so the current GDPR, we have to be expansive in our interpretation of this right. And this is, I think you mentioned transparency. One of the things that struck me, and maybe in the final round of questions, this is something that you can also reflect on, but something that struck me in the discussions in this CPDP compared to 10 years ago is that 10 years ago, everyone was kept talking about trust all the time. And I have barely heard it. I think I can count the number of occurrences of the word trust on both of my hands, but this also includes the number of times I have just said trust right now. So it's very limited. And something that also strikes me in this reflection is that in some of the problems that we hear coming back from people on the ground, from sometimes having data subjects who are really irritated with the data controller, is that there seems to be indeed this type of fundamental lack of trust at times, where it makes it even difficult for DPOs to be able to have a dialogue with people doing these access requests, because that is the level of lack of trust that we have on the ground, which has also consequences for the profession. But yeah, it also leads to adding to an already significant workload for these professionals. There can be times where maybe we could open the discussion for disproportionate efforts. The Commission has been trying to address this in the proposed Digital Omnibus. I will not expand on all of the contentious issues in the Digital Omnibus because the previous panel in this room already did a great job at doing so. But I would like to ask you whether each of you, believe that the proposals made in the Digital Omnibus are the right ones to address the issues that we have raised or not, and whether maybe you have your own suggestions to make in this policy debate. And then we will open the floor, of course, for questions, interventions, disagreements, expressions of agreement later on, so feel free to prepare already your questions. We don't have a specific order here, but I see, René, you are reaching for the mic. So
yeah, in that case, I can, I think, be pretty short. So I think, at least when we're talking about the part that has anything to do with Article 12 and 15, everything should be just not be changed. That's very simple, since the court is doing an amazing job to clarifying everything. So this maybe something have to be clarified, but they are in the process of being clarified in the exact way that our constitutional system is intending it to happen. And so not only is it not necessary, it's actually doing the exact opposite. Like a lot of things that are finally becoming crystal clear would all of a sudden become again a complete mess. Especially because not only the underlying ideas are kind of wrong, I think, also the way at least current proposal is written is so vague that it is another decade of nonsense case law. So that's the short of it.
Short, but to the point. Florence, maybe you have a slightly different take on this.
As a CETPO representative, I cannot say that DPOs are against the Commission proposal, because in our survey, we made a survey, and we had almost 700 respondents in the data protection professionals field. And the results are really in favor of the Commission's proposal. So I'm not talking personally, I'm talking from CETPO perspective. We had 65% of respondents who are approving the proposal to give the data controllers the possibility to refuse or charge a fee if the right is used for other purposes than data protection purposes. And 72% approves the proposal regarding the simplification of the burden of proof for excessive access requests. But it's a survey, and it was a yes or no question. Do you approve, or do you approve? Don't you approve? So I think it means that DPOs are really facing problems and they want answers, but I'm not sure it's the European Commission's proposals which is going to give them really solutions. Because personally, when I read the proposal, I agree with you. I don't think it will be giving really tools for DPOs to refuse or to charge a fee for certain misuse of the right, because with recital 35 now, I don't know what is an excessive request and what is an unfunded request, because there are two different notions. This notion of unfunded, it's already in the GDPR, but with the new recital, now I don't know what is the difference really, because it seems to cover very similar cases, but the regime of the burden of proof is different. It's only when the request is excessive that you can have this specific burden of proof with these reasonable grounds to believe that the request is excessive. And there are some explanations in the recital explaining that in one case, you can have this simplification of the burden of proof because it's not in your area of responsibility as controller, because you cannot have the proof, but the examples that are given are not good, in my opinion. So there will be a new problem for DPOs to find if they are in the case of an excessive request or in the case of an unfunded request. And even if in the excessive request case, with this notion of reasonable grounds, I don't know exactly what will be asked to DPOs to document these reasonable grounds. And as you don't have to give grounds, what will be your result? As a data subject, you don't have to justify, or if you justify, you can just say, it's to check I use the right to check the lawfulness of the data processing, and that's it, even if after I will use it for other purposes. So for me, there is really a question to be solved and an issue to be solved for DPOs for these very specific cases. But the answer of the Commission will not work, in my opinion. It's not the SETPO's opinion here. So we really need to work more about this question. And I agree with you, the question of proportionality is really important, how much effort I have to give as a controller to answer response. But we will have the problem if you need to assess the proportion and to see if the efforts that you have to make are proportional to the request, it will be easier if you know why. So in any case, there is a moment where you need to know why the request is made, and if it's proportional, if the request is made to claim because there has been a discrimination, it can be really important to give all the data. But if it's only to make the request because I know you will have to work on it and you want only to bother you, it's not the same. So without the why, we have always a problem to assess this proportionality. So you asked a proposal. I can just critique what is proposed, but I have no specific proposal today.
Thank you for this input. And indeed, I mean, we've talked about lots of things, but time is constrained. But one of the things that we discussed when we were preparing this panel is also Article 15, paragraph 4 of the current GDPR, which states that you also have to respect the rights of others, because sometimes the data may contain things that affect also the rights of others. And there you often end up having to do a balancing exercise, saying, okay, that maybe one of my employees has a right also to privacy, actually, and data protection, but also other types of rights. And then there can be a contradiction between the data subject access request not having to be founded by an explanation for the motive, and the fact that then you need to do the balancing exercise, but without really having a way to know what you are balancing the interests of those others with. And at the same time, for reasons that René talked about, but also that you discussed as an answer to the previous questions, there are also very solid reasons why, from the data subject perspective, having to give a reason can be problematic. So far, it's probably something that still needs a lot of reflection. But there are still have some hope to find some good ideas, because there are still two excellent panelists left who haven't given their proposals. So you have a big burden on your shoulders. I don't know who wants to go first.
Yeah, my wonderful colleagues and I have compiled you a list. So one, this goes to something I said earlier. Any attempts to further define what a vexatious request is should really clearly separate DDoS-style things from collective action. So a core one, require a data dictionary. That's such a basic thing, but is something that we never see. And that DSARs are multi-stage often, and for something huge like logs, data subjects need that initial information about what is even available to do more. And that's something that is mutually beneficial. It should be specified that requesting to substantiate potentially unlawful processing is never abusive. Info about data retention periods should be required, and the data retained by sub-processor is mandatory, and the GDPR roles of the party, because DSARs aren't just about the data, it's about the legal relationships between parties and whether that data reflects what those relationships are. And finally, there should be a recital that broadens the scope of access to personal data to the kind of things that scare data controllers, because they are huge, like metadata and logs. And then specify that if you have a download your information portal, it should allow data subjects to say how they want it, because like an HTML file is great for some people, but horrible for others who want to do further post-processing. And it should be required that if you do have an automated tool, it gives you that data dictionary so you can make further requests. And this is, things that when you do get the FXHS request, it's easier for the controller to protect themselves and say, look at how much we've done up front to help data subjects. I can show that this is a deviation from our norm.
So Jessica?
Yes, so I can just add on things very basics, actually. What we are experiencing now is that we have the GDPR, but it's poorly enforced. These are basics that we can improve immediately, and what we see also is that we need, for the companies, the data controllers, more capacity to answer to these requests. And on the side of the data subjects, we need more capacity also on how to understand this data, process it. It's not you just get your data and that's it, you understood everything. We need places, collectives, interdisciplinary expertise to actually understand this data and make it reusable. So I think we need also resources on that side, even outside the law and the proposal that we can make here. And now I want to answer to your previous question that I didn't answer, is like, do you get some useful data? And I want to answer just to illustrate what we might be losing with the Digital Omnibus. Even cases where companies don't answer, it is already a legal proof to contest problems with these companies. When we get little data, it's already a huge step. For example, with content moderators in Kenya and Nigeria, we requested their data to the subcontractor of Sama Teleperformance that is working for Meta and TikTok, for example. And actually, these are occupations today that are very precarious in oppressive contexts. And we got data from just their contracts or the NDAs that they signed and that they were never given a copy. So it is already two documents as data that was recovered and that can prove a relationship of employment in there. And not only with the subcontractor, but also with Meta, because we found a dashboard of Meta where they could register their working times, although they were working with Sama at the first place. So, and what we're losing also there is that we tracked data ecosystems that are very complex to understand there. We saw that Sama was also sharing data with a company in Switzerland for tax compliance. So it builds on what was said. It helps auditing legal relationships, actually, that are across borders. And we use the GDPR with Kenyans because there was some data flow going to the EU. So it is also a means that actually it's helping jurisdictions with law enforcement because they don't have a national regulation or because they have a weak one. The GDPR also helps in this context. And then we have the case of Genevan drivers, where actually we use the right of access with about 30 drivers that request their data, and we got geolocation time-stamped for every little action they were doing on the app, scrolling, when they get out of their houses, when they went into the car, we saw the speed also. And this was super useful data for the regulation of platforms. And in general, it was, in Geneva was the first tripartite social dialogue of regulation of a platform, where they reclassified all drivers automatically as employees. It hasn't been the case in other contexts where it is case per case, and then, for example, worker infraction change and files, they go to court and they do individual cases. Here was a collective action, and we provided data for the table of negotiation with Uber, the unions, and the state. And it was a means, actually, we talk a lot about getting transparency, accountability, but it was a way to verify what Uber was saying about the work organization, and also for the state, because sometimes we talk about a lot the data subjects that don't have the power or are in asymmetric relationships, but also the state and also unions, the institutions that defend us, don't have today the power to understand the data collection processes we are facing.
Thank you. Thank you very much to all four of you, both for the proposals that you've made, your analysis, but also for sort of giving life to data protection, because data protection can seem like a very dry subject. And when you ask most people, beside the realm of CPDP, do you have any data protection related experience in your life? Most people will say, well, no, I'm not a technician, but I really appreciated how you were able, all of you, to really substantiate the discussion with real-life examples from all sides. So thank you very much for that. Do we have questions, interventions, disagreements, agreements, new proposals to solve the problems? Yes, one question here, another one here, and so let's take the first two questions.
Hello, Romain from Accept You here. In the Digital Omnibus, there is a very contentious article about standardization and centralization, which does not apply to the right of access. But I wonder, like, from your point of view, do you think that automation mandated by law could be a way to enforce access of data, like in a more strengthful way to data controllers?
Thank you. Was there another?
Thank you. My question is very unrelated, so maybe it's better to answer first, or do you want me to ask my question?
Let's take the first two questions, and then we'll give a first round of answers, and then take another round.
Okay. So yesterday in another panel, one discussed.
Maybe sorry for each people asking question. If you can introduce yourself very briefly.
Okay. Sorry, Jonathan Keller, Paris 8, also. Yesterday in another panel, one discutant said access right doesn't provide an explanation. We just, for example, just have to write to read the privacy policy. Are you agreeing with this position, or don't you think there should be, when you have data access, an explanation explaining what are the use of those data, way beyond of the sole privacy policy?
Okay, thank you. So two questions. One, can we automate, should we automate DSARs, as we say in data access right lingo, maybe using technical standards? Can that help? And then the other question is, does the right of access, is it true that the right of access includes or doesn't include the right to explanation?
From my point of view, it will be difficult to automatize all the system, because you have to take into account the rights of third parties. And that is what is the most difficult part to deal with when you are answering to a data access right request, because it's really very, very subjective and a case-by-case analysis, because sometimes you don't have to just identify that there are data from third parties. You have also to balance if you have to give them or not. So it's not just, I know that AI is really intelligent now, but I'm not sure it will be capable to make this analyze, to balance the rights, and I don't want an AI to do that in reality. So partially it could help, but put that in the law that it must be automatized, I'm not sure it will be a good thing. And to your question, Jonathan, no, for me it's not the same information when you are in Article 15, especially because it's a specific data subject which is asking, and the processing that you are describing in a privacy policy are very generic and not specific to that data subject. For me, it's not the same information. Some of the information will be the same, but it's not the same. I don't know if I have answered your question. But,
So on the same topic, it allows me to come back also to a question about what should be changed. Should we change the law? And so one thing is I think automation can be a great tool, and when it's used in the right way, it helps. So, for example, if you would have what did you call it, a data phone book or a data dictionary, and you have like a data download tool, for example, that already provides the majority of the data, and then and a clear way of still addressing the controller, great. And I think there are some companies that use it in a way that actually helps complying with the right and supports data subjects. I think, though, that there are two very important things. One is there's a certain proceduralization, managerialization of the procedures, where what falls within the process becomes easy and easy to access for the data subject, but it also becomes the border of like whatever is not in that automation becomes actually harder to request. And of course, that depends on the implementation. It doesn't have to be like that, but in practice, I think all of us who did access REST know that this is the case. And in my personal experience, for example, Google is the perfect example. They had a download tool pretty early on, but really try to get something that's not in there. Unless you bring lawyers and you start to threaten them, it's impossible. And that's my second point. I think it's the big elephant in the room, even in this discussion and in general in this discussion. It not only does the right of access to personal data give the right to access a lot of information, but that information is powerful, and almost in every case, the data subject wants to and can use it to contest, to fight, to resist. So we have to really be clear that all separate from that it might be difficult to actually answer a request sometimes, there is a very strong incentive not to answer, or to answer only in a limited way. And I think this is still not clear enough in our discussions, especially also if we look at data protection authorities. I often see, well, a data subject did a request, didn't get a full answer, so then when the data subject finally complains to the authority will, send a letter to the controller and say, okay, next time you really have to provide more information, and that in that individual case, the controller might do it, but that doesn't change the structural imbalance. So even the next data subject, the controller has no incentive not to just sit back again and provide just a tiny sprinkle of information and then just see what's coming. So I think when we foreground this internal contrast that there is in essence in the right of access, it should inform how policymakers and how authorities should also deal with those requests and with trying to support data subjects. And I think at the moment, there's a lot lacking there. But I also think that GDPR also gives, especially authorities, enough powers to do so. It's more about the culture of wanting to do that than actually to getting more rights to the authorities.
May I address the data explanation question? So if I sent a data subject access request, either at a privacy company or in my free time, which I do, everyone here should write a DSAR, and they gave me data but said I didn't have a right to an explanation, I would send the exact same request back with one more line that says, oh, and I want an explanation based on the transparency principle of the GDPR. So I think that's a really succinct pushback to that idea. And so that's a high level thing. And now a boots on the ground thing, I'm going to tell you a very brief story about the worst DSAR I've ever sent. The worst experience I've ever had sending a DSAR. So this was actually during my master's with the CCPA, the California Privacy Act, but I think still relevant here. I sent a DSAR request under my CCPA rights, even though I lived in Pennsylvania, but they gave the right anyway, which goes back to what you were saying about how these rights help people even if you're in a different place. And they verified my identity with a question about what was the high school mascot of the high school near my grandma's house. And then they responded saying they didn't have any data about me. And this is, again, this is in the context of the US, but this is still very typical for what you can expect in any scenario. And when we pushed back and got more data, and this gets directly to your point about explanations, a lot of the data was labeled like A1, I was labeled as 0 or something like that. And if you don't have a right to an explanation, a lot of the time you're just going to be given data that you have no ability to interpret. Because when we push back again, we found out that A1 was code for what would be here like special category data. It was like an ethnic identity code. So yeah, that's a very high level legal pushback on that argument, and then a very specific on the ground example of how explainability is oftentimes just not exclusive from basic legibility.
I think we have time for a few more questions, reactions, testimonies. Yes, please. And if you'd like, please, you can state your name, affiliation if you want to. You don't have to, but.
Andreas Heuselmann. Andreas Heuselmann, Open Universiteit. My question actually relates to the right to obtain a copy of personal data being processed. So we know from CGU case law that actually controllers should provide a faithful reproduction of all the personal data undergoing processing. So my question to you is, in practice, how do you see controllers complying or not complying with this interpretation of the European Court of Justice?
Okay, any other hand in the room? No, so maybe, I don't know if any of you want to take the floor, but I think Jessica, you might have extensive experience.
Well, maybe if I understood well, it relates to all the problems I have mentioned before, right? That they, when we request our data, basically the answers are very different from one company to another, and it can vary from we don't have any data, or it's all in the privacy policy, and you're like, no, this is not what I asked. I asked a copy of my data. And it can be also, here's your data, and it's from the last 3 months of my usage in an app, and then we have to specify, no, I want it for the whole period of my activity in this. And then it can be also different from one person to another. One data subject got all the geolocation timestamp, and then the other one no. Somebody received it also related to the format. We did data access request to the train company in Switzerland, and the first person received a printed document by the post. And other ones then receive a PDF, which it's also a problem because then you cannot process this data when it's a lot of data. So we have to specify we want a machine readable format, but it has to be also understandable with explanations like code book and so on. So it is not a standard process yet. The quantity, the variety, yeah, it changes all the time also, because I understand the softwares also evolve and they are in continuous versioning. So you might not be collecting one type of data at some point, but then another one. And sometimes we see errors, which are interesting for us. Like there was an Excel with the working time of a delivery rider, and then a comment of the DPO saying delete this data because they cannot see it. So yeah, it's very much.
We don't have a lot of time left, but no, Jacob, you
Oh, yeah,
please go ahead briefly. And if do any of you two also want to add afterwards? No,
Okay, just a quick addition. When I file data subject access requests, I am typically doing it as a part of a DPIA that the controller knows is happening. So I'm doing it from a position of privilege, really, that a data subject would never have, because the controller can see, oh, there are consequences. And still, data subject access rights remain one of our most consistent risks across reports. It reminds me of, there's a paper I read once about how if you get a bunch of privacy professionals in a room and ask them to read a privacy policy, they'll all come to a different conclusion. It's a similar thing where if, it's just even from a position of privilege or influence that a data subject typically wouldn't have, it's still usually demonstrably incomplete.
Okay, so I haven't heard the bell, but I believe that if I'm not mistaken, we are at the end of our time. So please join me in a big round of applause for our participants. And if you had any frustration that you would have liked this to go on and on, I can reassure you that I think that this conversation is going to go on and on. So I'm sure we'll be able to meet at the next CPDP and continue from where we've left.